Members, it's the appointed time. We have a quorum. I call to order the meeting of the Bills Committee on Companies Amendment Number 2, Bill 2024. Agenda item number 1, election of Deputy Chairman. The Secretariat has issued a notice to notify members that we have received one valid nomination for the office of Deputy Chairman, and the nominee was Mr. Adrian Ho. The nomination was made by me and seconded by Dr. Junius Ho. And in accordance with the relevant rules, if members agree, we may elect a deputy chairman, and I would like to ask members' opinion right now. I believe members agree. There are no objections. I declare Mr. Adrian Ho duly elected as the Deputy Chairman of the Bills Committee. Let's proceed with the meeting. Let's invite representatives of the administration to come inside the conference room. I would like to welcome Mr. Keith Giang, Deputy Secretary for Financial Services and the Treasury Financial Services 3, and his team to come inside the conference room. And I would now invite representatives of the administration to brief members on the bill. Deputy Secretary, when you're ready. Thank you, Chair. I would first like to thank members for joining the Bills Committee, and we welcome your comments. Let me first talk about the background and contents of the bill. We have seen compliance costs getting higher with different policies in the world. We now have, for open-ended fund companies and some non-Hong Kong fund companies, we have put in place a redomiciliation regime. They have been quite successful, and there have been calls for a redomiciliation regime being put in place for non-Hong Kong incorporated companies. Therefore, we are introducing the regime to address the cause. In the company's ordinance, we will put in place a domiciliation regime, and with the regime, companies may maintain their identity and business continuity while being redomiciled. There are several requirements. First, they must conform to the risk management requirements. There should also be proper protection of members of the company. The registrar of companies will make sure the registration is compliant with the requirements, and they may refuse the registration if it is believed that the redomiciliation is for unlawful purposes or is not in public interest. The redomiciled companies will entitled to more or less the same rights as Hong Kong incorporated companies. Within 120 days after the issuance of the certificate of redomiciliation, the redomiciled company must deregister from its original domicile. Otherwise, the company's registry may revoke the registration. Apart from exceptions stated in the bill, the redomiciled companies will be regarded as having the same status as Hong Kong incorporated companies. We will be amending relevant legislation, including the Companies Ordinance and 39 pieces of legislation to ensure the redomiciled companies will enjoy the same status as Hong Kong incorporated companies. There are also regulatory regimes such as in the banking and insurance sectors that regulate relevant institutions. Therefore, we will amend relevant legislation as well to accommodate the redomiciliation regime. Chair, we have consulted the Legislative Panel on Financial Affairs as well as the relevant stakeholders, business chambers, professional associations, and relevant advisory bodies, as well as some firms. The proposals are generally supported. The bill has suitably incorporated feedback received during the consultation exercise. Chair, we have representatives from various bodies today to answer questions from members. That's it from me. Thank you. Thank you. I'll now invite questions from members. Members who would like to speak, please press the request to speak button. I'll read out the order in which members are going to speak. Mr. Chen Kin-po, Ms. Carmen Khan, Mr. Chen Pu-lang, Mr. Adrian Ho, Ms. Doreen Kang. We have ample time, I believe, so I'll assign a 6-minute time limit. First to speak, Mr. Chen Kin-po. Thank you, Chair. For various reasons, we have some insurance company with much business in Hong Kong chose to be incorporated in Bermuda. However, with EU requirements, we will have minimum top-up tax and various forfeits tax charge in those jurisdictions as well. So many companies now plan to return to Hong Kong, or even some new companies are interested in moving to Hong Kong. We have quite complex procedures at the moment. We have now companies having to go through the courts, and even a single policyholder can object to the application made by insurance companies at the moment. With this bill's provisions, we believe it would streamline the procedures, simplify the procedures for redomiciliation. I fully support the proposals, and I believe many insurance companies have expressed interest in redomiciling to Hong Kong. Let me declare an interest also. I am representative of the insurance sector. I note the legal advisors, actually the paragraph 10 of the LSD report. It says that the applicant is required to obtain consent from its members for redomiciliation. Such requirement must have to be complied with if under the law of the place of incorporation of the constitutional document of the applicant, the applicant is required to do so. However, if there's no such requirement, a resolution for the redomiciliation must have to be duly passed, etc. So why is there such requirement in the first place? That's my first question. Also, I want to ask about paragraph 15 of the same paper. It says, under the proposed new section 820E of chapter 622, the applicant must be deregistered in its place of incorporation within 120 days after the redomiciliation date or within a period as extended by the registrar. Otherwise, the registrar may revoke the registration. I want to ask why the number of days is 120. Thank you. Deputy Secretary. Thank you. With the 75% requirement for consent of members, we do need to make sure there is consent from members of the company. So first, the company must be located in a jurisdiction that would have outward redomiciliation regimes. So first, we would need to check whether there is, under the law of the place of incorporation or the constitutional document of the applicant, there is a requirement for applicants to obtain consent from members. And in Bermuda, there is such requirement, but the threshold is 50%. If there is no such threshold requirement in the jurisdiction, we will adopt the special resolution threshold in Hong Kong that is at least 75% of the company's members consenting to redomiciliation. This is to offer protection to members, and I believe insurance companies and banks should not have a problem meeting this requirement. For insurance companies, would it include policyholders? We're talking about members, that is shareholders of a company specifically. As for the 120-day requirement for, or period for revoking the registration, if documents are submitted, the required documents are submitted, the company's registry will issue a certificate of redomiciliation. That would mean that the company has essentially become a redomiciled company. But we also require the company to deregister from its place of incorporation. As for 120 days is enough, we have consulted various stakeholders. We originally set the number of days to be 60, but we have heard stakeholders say such processes may not be completed within 60 days in certain jurisdictions. That's why we have extended it to 120 days. We have also provided in the bill some flexibility. If the applicant needs more than 120 days, they can provide information to the company's registry for consideration, and the registrar may extend the period if necessary. But the policy intent is to have the company deregister as soon as possible. I understand that you have amended the period from 60 to 120 days, but has someone raised any concerns afterwards, saying that 120 days is still not enough? Deputy Secretary, thank you. After we have extended the period to 120 days, we have not heard any concerns raised by stakeholders. We have also referred to other jurisdictions' practices, such as Singapore. They have only 60 days. And as I said earlier, there is flexibility in the bill's provisions. If necessary, the company's registry may extend the period if necessary. Thank you. I would like to follow up on what Mr. Chan Kim Po asked about the 75% requirement. It says that the resolution has to be duly passed by at least 75% of its members. But you talked about the special resolution threshold. But I think the wording is, or the concept is different, because with 75% special resolution threshold, it's about members being present. But here, it's actually about 75% of the company's members who are entitled to vote. And that is so much, there will be so many more people. So are you talking about the special resolution threshold, or are you talking about the 75% of members who are entitled to vote? Well, we are talking about 75% of members being present at the meeting to vote. Well, in the provisions, let me say this. Let me take a step back first. It would have to first depend on whether there is relevant requirement in the place of incorporation. If there is, they would adopt their threshold in the jurisdiction. If not, the 75% requirement would be adopted. Say in Cayman Islands, For the outward redomiciliation regime, they do not require consent from members. If the companies incorporated there would like to redomicile to Hong Kong, then we would need to adopt the 75% threshold. For Cayman Islands, it would be 75% of the members present at the meeting. That is the threshold they adopted. So this is on par with what we have. For special resolution threshold, we deem that it is enough because right now special resolutions would be used for decisions such as liquidation. Thank you. Ms. Karam Khan.
Chairman, this is a crucial piece of legislation. I support the legislative amendment. A member from the insurance sector just now said there is a need for us to have a company redomiciliation regime in Hong Kong. Years ago, we had a similar regime. According to statistics, as at the middle of 2024, there were 2,500 listed companies in Hong Kong, of which 70%, that is about 1,700 companies, were incorporated in BVI as well as Cayman Islands. I believe some insurance groups would like to see this regime, so I express my support to this proposal. I think it would be helpful if there is a PowerPoint presentation. Just now, the briefing from the administration was rather simple. I'd like to ask about paragraph 9 of the paper. It's mentioned here that some stakeholders suggested putting in place a two-way regime. However, the administration is only proposing an inward regime. Currently, there isn't an outward regime. With reference to other jurisdictions, is it common to have a one-way regime in other places? Well, the original domicile, for example, Singapore in 2017 put in place a company redomiciliation regime, and is there a need for the jurisdiction to have a two-way regime in order to bring in companies from original domiciles to redomicile in Hong Kong? Well, in the Blue Bill, it is mentioned here that the original domicile of applicants according to our bill, we do not prohibit applicants from coming to Hong Kong, but there has to be a deregistration system. But this is different from redomiciling, so I want to ask about the wording in the Blue Bill. Also, in Singapore, there is economic substance requirements imposed on companies. Say, for example, they require the redomiciling companies to have $10 million of assets, or there is certain requirements in relation to the number of employees. So this is to make sure that they have substantial businesses engaged by the redomiciling companies. So I want to ask if we are imposing similar thresholds on the incoming companies. My other question concerns the 120-day requirement. After issuing the certificate of redomiciliation, if the company hasn't yet deregistered from the original domicile, there are certain uncertainties. Will you consider issuing a notice in the local newspaper to prevent any problems arising from the uncertainties? Deputy Secretary, I thank the member for the questions. Let me respond one by one. Currently, we are proposing a one-way, that is an inward redomiciliation regime. We've looked at places around the world with company redomiciliation regime. Take Australia and Singapore as an example. They only have in place an inward regime. There's currently certain demands for inward regimes, so that's why we're prioritizing the introduction of an inward redomiciliation regime. The second question concerns whether the original domicile requires Hong Kong to have a two-way regime. Well, let me explain why there is such a requirement. The core of the redomiciliation regime is to ensure the continuity of the business and to retain the legal identity of the incoming companies. So for places with redomiciliation regimes, they all have to ensure the business continuity, and they also have in place a deregistration system. So we include in the bill that the original domicile does not prohibit the companies from redomiciling to other places, to make sure that the original domicile will allow the companies to transfer their domiciles to other places. The third point is about the economic substance requirement. Indeed, in Singapore, there's requirement imposed on the incoming companies in relation to their assets as well as the number of employees. However, there are no such economic substance requirements imposed by other jurisdictions. Our goal is to attract companies of different sizes and scales. We will play a gatekeeping role in relation to checking the solvency as well as integrity of the companies. As long as they fulfill all the relevant requirements, we welcome them to redomicile to Hong Kong. Say, for example, if you want to set up a new company in Hong Kong, there are no such requirements concerning the assets or the number of employees. Say a company of a small scale, if they choose to redomicile to Hong Kong, they will increase the demand for relevant professional services. We also because, for example, we ask them to engage auditors from Hong Kong. To address your last point, according to our regime, we ask the applicant to provide certain proof to show that it has informed all its creditors. There is such a requirement in place according to our proposal. So we have to make sure that all the members of the company as well as creditors will be informed of the redomiciliation. We will issue the certificate of redomiciliation, and the record will be included in the company registry, which is subject to public inspection. And the company will then have to deregister from the original domicile. It is only after it has deregistered from the original domicile that it is considered to have completed the redomiciliation process. Mr. Chen Pui-Leung, I speak in support of this bill. This bill will allow financial institutions to bring their businesses to Hong Kong. This will also help bring in companies to set up headquarters in Hong Kong. I'd like to ask about the application eligibility. Concerning the solvency of the applicant, it is said here that the applicant will be able to pay its debts in full within the period of 12 months beginning on the application date. Why aren't you asking the applicant to pay its debts in full no matter when? Why are you specifying the 12-month period here? Please explain the rationale behind. Upon the passage of the bill, companies intending to redomicile to Hong Kong, how long would it take for them to complete the application procedures? It is said here that they will have to talk to the Insurance Authority as well as the Hong Kong Monetary Authority beforehand. Have you set a KPI on when the relevant financial regulators or the internal government departments have to complete the processing of the applications? Also, have you made an estimate of how many companies will redomicile to Hong Kong after the bill is passed? 3 questions, administration. I will respond to the second and third question, and I'll ask Eric to reply to the first question. On how many companies would be interested in redomiciling to Hong Kong, we haven't yet set a hard indicator. As mentioned, we would like to introduce a regime that is simple and accessible to companies from all sectors, as well as companies of all sizes and scales. We will play a gatekeeping role, so we welcome all kinds of companies to come to Hong Kong. We understand that a number of companies from the insurance sector, on one hand, they are trying to catch up with the requirements, and at the same time, they are preparing to redomicile to Hong Kong. The other question concerns companies from the banking and insurance sectors. For Hong Kong incorporated and non-Hong Kong incorporated companies from these 2 sectors, there are 2 sets of standards. Take insurance companies as an example. Say an insurer applies to redomicile to Hong Kong, we need the insurance authority to step in and make an assessment so that we can decide whether this non-Hong Kong incorporated insurer will be able to fulfill or comply with the relevant requirements and laws in Hong Kong. That's why we need the insurance authority to make an assessment beforehand. Even with a certificate of redomiciliation, if it is of the insurance authority's view that the company concerned cannot fulfill the requirement, then we won't approve the redomiciliation. So in all our documents, we will specify that companies from these 2 sectors will have to approach the insurance authority and the HKMA. There will be a communication mechanism in place in case the companies from these 2 sectors have not got the approval from the 2 regulators. Then we will be aware of them. We'll be aware of that situation. As to whether there will be a performance pledge concerning the time it will take for us to complete the processing of the applications, there is no such KPI, but the 2 regulators will approve the applications as soon as possible. At this point of time, we won't be able to come up with a fixed performance pledge. I'll just say that the 2 regulators will approve the applications as soon as possible. Mr. Eric Lee, on the requirement about solvency, this is one of the requirements to be fulfilled by the redomiciling companies. We have to make sure that within the period of 12 months, the applicant will be able to pay its debts in full. As to how the applicant will be able to prove that, the applicant will have to show that the board of directors have given the opinion that the applicant will be able to pay its debts in full within the period of 12 months beginning on the application date. When we decide on the solvency of the applicant, Well, we have already made reference to the practices in other jurisdictions, including Singapore. There is the same requirement imposed by Singapore to ensure redomiciling companies will be able to pay its debts.
Any follow-up questions from Mr. Chen? Well, I want to clarify, does it mean debts in full within the period of 12 months beginning on the application date? Hence my question, why not pay off all the debts instead of only within the period of 12 months? I think the Deputy Secretary said they referred to practices in different jurisdictions. They also referred to the solvency requirement in Chapter 32J Companies winding up a miscellaneous provisions ordinance. I would like to ask if the administration has anything to add. Are you simply adopting the same standard in that ordinance or what? Thank you. When preparing this bill, we have referred to the practices in other jurisdictions, such as the one mentioned earlier of Singapore. We believe with this 12-month debts, that would already prove the solvency of the company. We do not plan on making it to be paying off debts in full. As long as the applicant is able to pay its debts in full within the period of 12 months beginning on the application date, that is acceptable to us. Any follow-up questions? None. Mr. Adrian Ho. Thank you. I support the bill. I have several questions, however. I hope that with this bill, after it has been passed, we can do much in publicity. We have some companies that have parent entities incorporated in the mainland. There are also companies that do not even have any operations in Hong Kong. If we can attract these two types of companies to redomicile to Hong Kong, that would be ideal. Have you assessed how much economic benefit this regime would bring to Hong Kong? What are the potential risks according to your assessments? If this will positively impact the economy, for the two types of companies that I mentioned, will you actively reach out to the companies concerned to ask them to redomicile to Hong Kong? Also, I want to ask, apart from Gazetted, how will you promote the redomiciliation regime to companies in different parts of the world? Also, I hope that we can have some flexibility with audited financial statements. I also understand that some stakeholders want more transparency because we do have a requirement for integrity, but integrity means a lot. Is it just financial integrity, legal integrity, or the scope of the functions of the company or the audit procedures? I do understand the vetting process will be quite quick, but if we can enhance transparency, that would even be better. On the economic substance requirement, there are some entities with business in Hong Kong. If they're domiciling to Hong Kong, that would make a lot of sense. But for other companies that have no operations in Hong Kong, they most likely look at tax system as well as some facilitating measures when considering whether to redomicile to Hong Kong. Because we do not have an economic substance threshold, we may have companies opening shell companies in Hong Kong. We have seen that happen with jurisdictions with inward redomiciliation regimes. And this is often a way to evade taxes or legal responsibilities. How can we prevent these companies from abusing Hong Kong's system for tax evasion, while making sure these companies would contribute to Hong Kong's economy? There are some 6 questions. Well, I would say that they can be grouped into 3 questions, or 2 major categories of questions: how we are going to play as a gatekeeper and what we're going to do in terms of publicity. In terms of publicity, as Mr. Adrian Ho said, we are indeed very much interested in getting the 2 types of companies to Hong Kong. We have some insurance companies and listed companies that would fall into the 2 categories mentioned. We actually have some figures. We have 2,600 listed companies, and 3/4 of them are registered in Cayman Islands and Bermuda. And this is the group of companies that we hope to attract to redomicile to Hong Kong. Not only will we gazette the bill or about the regime, we will have much information on the company's registry's website on how to apply for redomiciliation, the process involved. We will also have ETOs help promote the regime. We also have Invest Hong Kong and OACs. We have different bodies and departments that are looking to attract inward investment. They will try to promote the companies. The problem is we don't even have a regime right now. When we have a regime, we will be able to promote it as an advantage. As for the potential risks, as Mr. Adrian Ho said, as we do not plan on imposing an economic substance requirement, we would welcome pretty much any company that would satisfy the requirement, but then we would also play the gatekeeping role by asking companies to submit necessary documents for us to understand the background of the companies, the member composition. Lastly, I will talk about the potential benefits of the regime. We cannot exactly quantify the benefits, but with one more company redomiciling to Hong Kong, we will have more of them take advantage of Hong Kong's professional services, generating benefits for the economy. Mr. Eric Lee. Thank you. Well, I think we can look at it at different perspectives in terms of benefits and risks. First of all, the companies would have to inform their creditors of their intention to redomicile. And according to Schedules 6A and 6C of the bill, there are some documents that the companies have to submit, including basic information about the company, whether they are incorporated in Hong Kong, whether they are a listed company, and some information about their share capital. They also need to submit some documents such as their accounts. Once the company's registry received the required documents, if the requirements are met, apart from issuing the certificate of redomiciliation, the company's registry would also register the bundle of documents submitted by the company in the company's registry. If one wants to inspect the documents, just like other Hong Kong incorporated companies, one may conduct inspections through the company's registry. The Deputy Secretary also mentioned that within 120 days, the applicant must deregister in their place of incorporation. If they cannot meet this requirement, the registrar may revoke the company's registration. If the revocation is made, that would be gazetted as well. Once a company has become a redomiciled company, they would have to conform to local legislation, including information on beneficial ownership to make sure such information can be inspected through the company's registry. So this is information that would be available for the protection of various stakeholders. Thank you. Mr. Rincon. Chair, I may have to speak for 2 rounds. Let me just say this in advance. Say for Singapore, as Ms. Carmen Khan said, we have other jurisdictions imposing more requirements than we do. There is the economic substance requirement, say, for the scale of companies. I have another question about relevant requirements. Would you require companies to be incorporated in common law jurisdictions? Some jurisdictions do not have this requirement, so why am I saying that we may need this? It relates to the responsibilities of directors. When we talk about common law jurisdictions, they would have the same level of responsibility, so that would offer more protection to us. There's no such requirement in the bill at the moment. I want to ask if you have considered this, and if you believe after considering this requirement is not necessary, why? And I also want to say this, Ms. Carmen Khan asked a really good question about the 60-day and 120-day requirement. We have asked applicants to deregister in their place of incorporation after domiciling to Hong Kong. And it is said that 120 days should be enough for them to complete the process. If necessary, the period may be extended. I understand you want to facilitate the companies, but then, as Ms. Khan said, if the period is too long with a company having 2 domiciles, in law there can be risks, especially for creditors. So Singapore has imposed a requirement for 60 days. Recently, a UK has a consultation paper also consulting stakeholders on whether to shorten the period to 60 days. So I want to ask what your justification is for setting the period to 120 days. Have you considered the need to minimize risks? Apart from providing facilitation, we need to make sure we offer protection to members of the company as well as creditors. If we don't offer adequate protection to them, that would not be comprehensive in our consideration. I have another question. Can you talk about how some factors to consider are when we have the registrar thinking whether to approve the application? In the UK, national security threat is one of the factors. If you have some factors for consideration, will you consider them, including them explicitly in the bill? Also, I want to ask about the fees. You're charging very affordable fees. Would it cover the resources spent on the redomiciliation regime? All right, she asked 4 questions, and I think the factors to consider would need more time to cover. Thank you.
Deputy Secretary. The first question concerns whether the original domiciles have to be a common law jurisdiction. Well, we do not impose such a requirement. We just ask that the original domicile has to be a place with a outward redomiciliation regime. For traditional domiciles, a lot of them are common law jurisdictions, so there shouldn't be a problem. The other question is about the 60-day and 120-day window. We think that it will provide greater certainty for members as well as creditors of the company concerned if the period is made shorter. We have to strike a balance here. We have to look at whether the redomiciling company can finish the requirement within the set period of time and complete the relevant procedures in their original domiciles. After balancing different sectors, well, we make 120 days as the maximum period. Legally, we have to provide for certain certainties. We see the company issued with the certificate of redomiciliation, a company incorporated in Hong Kong, that is, they'll have to comply with the company's ordinance and they'll have to be regulated by the laws of Hong Kong. However, this company may not have deregistered from its original domicile, and the company may not have the incentive to complete the deregistration as early as possible. So we have balanced different factors as we came up with the 120-day period. The other question concerns whether we will consider national security as we approve the applications. The answer is affirmative. The registrar of companies will consider whether the applicant is likely to be used for purposes contrary to public interest or for unlawful purposes after it is registered in Hong Kong. After the company is issued with the certificate of redomiciliation, it will be regarded as a company incorporated in Hong Kong. That means all legislations applicable to Hong Kong will be applicable to this company, including the Safeguarding National Security Ordinance. Lastly, on the fees, there are two sets of fees. One that is about $5,000, the other about $1,000, which is the registration fee. There are two levels of fees that may apply. If the company applies online, it will be about $6,050. If it applies on paper, it will be a little bit cheaper. We have made reference to the fees charged by the company's registry, then the fees to be charged is about 5 times of that for a company to be set up in Hong Kong. Speaking for the first round, we have Mr. Ambrose Lam. I have many friends from the legal sector asking me about when this company redomiciliation regime will be established. Just this afternoon, a foreign lawyer asked me the same question. The lawyer asked me when the legislative exercise will be completed. Well, I guess it really depends on when this bill will be passed. On publicity, I understand that the government will work to publicize this regime. I am rather concerned about whether there will be concessionary measures. The member asked whether the fees to be charged are too low. Well, I care if will be dedicated teams helping these incoming companies. In Bermuda, there are people welcoming companies to go there for free. There are different tax concessionary measures implemented in Bermuda. Well, let me share with you some figures. As mentioned, there are 2,600 listed companies in Hong Kong. According to the companies registry, registered non-Hong Kong companies, there are about 15,000 in Hong Kong. How can we reach out to these 15,000 companies so that they will redomicile to Hong Kong? Administration. I thank Mr. Lam as well as the chairman for the questions. First, on concessionary measures. At this stage, we don't have any concessionary measures proposed, but as mentioned, we will step up publicity for targeted groups like listed companies. We see that 80% or 90% of these listed companies in Hong Kong, they aren't registered in Hong Kong, but they carry on a lot of businesses in Hong Kong. These are the targeted groups for us. Also, Part 16 of the Companies Ordinance for registered non-Hong Kong companies registered under Part 16, there are about 15,000 of them in Hong Kong. They carry on businesses in Hong Kong, but their places of incorporation aren't in Hong Kong. We have the relevant information so we can promote to them the benefits for them to redomicile in Hong Kong in a targeted manner. It is like attracting people to invest and emigrate to Hong Kong. We should bring them in to increase our tax revenue and revive our economy. Well, there were questions about the fees to be charged. According to the administration, it's going to charge about $6,050 and some $5,000. Will there be room to lower the fees? Well, we are going to charge the incoming companies on a cost recovery basis. We'll have to see how things go in deciding whether to review or adjust the fees. Mr. Paul Che. It looks like most of the companies in Hong Kong, in particular listed companies, they were incorporated in, for example, Cayman Islands and BVI. Well, there must be merits for them to do so. Their subsidiaries will not have to go through jurisdictions like Hong Kong, and they can save up a lot on taxes. Well, there's another amendment bill about BAPS 2.0, which will charge a global minimum tax rate. And this reduces the latitude for jurisdictions to introduce tax exemption. The administration is introducing this company redomiciliation regime, and the fees to be charged are rather low. Well, why should companies redomicile to Hong Kong instead of keeping their registration in, for example, Cayman Islands? For insurance companies, this will help reduce their compliance costs. But what will be the greater benefits if companies decide to redomicile to Hong Kong? Will there be any policies in place to attract companies to come to Hong Kong? Well, there has to be some actual benefits in order to attract companies to come. According to the paper, there will only be a one-way regime, which is going to be an inward one. It looks like there is currently not much demand for an outward regime. But you have to make sure that the original domicile of these companies do not impose any requirements to restrict them from transferring their domiciles. If there is only an inward regime without an outward regime, will there be the same situation in other jurisdictions which might restrict companies from redomiciling to Hong Kong? And as we introduce that inward-only regime, will it be difficult for redomiciled companies to transfer their domiciles to other places? I would like to hear from the experts about this. Now, we've been following the global trend in, for example, combating money laundering. We have been complying with the standards imposed by international organizations. But the trend is that countries have been decoupling from the U.S. Well, for Hong Kong, we haven't been following very closely in relation to our tax regime. We've been adopting a simple regime allowing companies with the freedom to hold different activities. However, the stock market recently in Hong Kong has been imposing different requirements. We haven't been following the standards, the international standards in this regard. And this has made us less flexible. So my question is, should we preserve our flexibility and competitiveness instead of jumping on the bandwagon? We should keep our capitalist system instead of following the trend, because the U.S. has been going the other way as well. Are we falling into the trap set by others if we just blindly follow the trend? Deputy Secretary, the first question concerns what are the benefits to attract companies to redomicile to Hong Kong. Some companies, they were registered in other places because they took into consideration taxes as well as compliance costs. As mentioned in our paper, we see that the compliance costs in different places have been on the rise. Say a company thought it would be able to save up on tax by registering its company in a place, but it seems like it's no longer the case now. The other question is that some jurisdictions impose the economic substance requirements on companies, asking companies to engage in a certain scale of businesses in the jurisdiction. Say, companies that carry on businesses mainly in Hong Kong but are registered in other places, basically they'll have to comply to 2 sets of regulations. It might be better for them to therefore redomicile to Hong Kong. Also, take the insurance sector as an example. If it keeps its registration overseas, apart from complying with the Company Act in the original domicile, it'll also have to comply with the laws concerning the insurance sectors locally. We have been introducing a low compliance cost as well as a simple and low tax regime in Hong Kong. Companies see that the compliance costs in other places have been getting higher, and it might benefit them if they simply redomicile themselves to Hong Kong by just complying with one set of standards. Also, will this regime affect our competitiveness? The answer is no. For some jurisdictions, they only have inward regimes only. Say in Australia and Singapore, they only put in place an inward regime as well. the UK is also considering putting in place an inward-only regime. Over the past few years, we've been in talks with the Bermuda government. We've been telling them about our progresses concerning introducing this company redomiciliation regime. And the Bermuda government did not stop us from doing so, because the insurance companies there would like to redomicile to Hong Kong, so we got the confidence from the Bermuda government that there should be no obstacles for us to introduce this regime. Now, we're not simply copying other jurisdictions as we introduce this redomiciliation regime. We are not imposing any economic substance requirements on prospective companies, but at the same time we will play a gatekeeping role. So we're not copying the practices of other jurisdictions as we launch this regime. We hope to be able to maintain our competitiveness. For companies that will benefit from this regime, we will like them to be able to benefit from this regime. As mentioned, there will be the global minimum tax of 15% for companies, and we hope companies will choose to come to Hong Kong. The problem is that we still have the stamp duty, and the directors' register will have to be maintained in Hong Kong, so when they transfer the directorship, they'll have to pay the stamp duty. This is part of the reason why companies are registered outside of Hong Kong. I see that some submissions say that there should be a waiver for incoming companies so that they don't have to pay the stamp duty. Well, this will be difficult because a redomiciled company will be regarded as a Hong Kong incorporated company. However, will you introduce a grace period or a buffer period so that when redomiciled companies decide to transfer their directorship to Hong Kong, they will be given tax concessions, and that this will incentivize them to redomicile to Hong Kong? Will the Inland Revenue will the IRD consider this? Thank you.
Thank you. I'll first give some answers. If necessary, the IRD's colleagues may supplement my answers. The redomiciled companies would not have to pay stamp duty. We're looking only for the companies to maintain their legal entity status as well as their business continuity. We would not require them to pay stamp duty. Also, in the redomiciliation regime, the crux is to make sure they would enjoy the same status as Hong Kong incorporated companies. Therefore, we will not provide them with specific tax concessions. I'll see if the IRD colleague has anything to add. Thank you. We have to maintain a level playing field. For Hong Kong incorporated companies, when there is a transfer of shares, stamp duty would have to be paid. As redomiciled companies are regarded as Hong Kong incorporated companies, they will first need to maintain a register of shareholders, and like any other Hong Kong incorporated companies, when there is a change in membership, stamp duty would have to be paid, so as to make sure there is a level playing field for both redomiciled companies and Hong Kong incorporated companies. That's it from me. We have Dr. Junius Ho speaking for the first round as well. Dr. Junius Ho, Thank you. I just want to get some information. Before I ask my questions, I would first like to express my support for the bill. I want to ask the Deputy Secretary. It says in the paper there are 14,000 to 15,000 companies in Hong Kong that are incorporated elsewhere. I think there may be even more. We have some companies that do not have a place of business that won't even be counted. So do you have some figures about this type of companies? They do not even have business registration. Do you have like some figures on how many approximately these companies will be? And for the 15,000 companies with a place of business, you will be charging them $6,000, and that would mean $19 million in revenue. If we count those that are not even included right now, we may get even more in revenue. So while we do charge relatively affordable fees, we may earn a lot. I also understand that redomicile companies would have to compile annual returns. They also have to fill in some ND forms. I believe that will bring about economic growth in some way. It would contribute to the economy. So I want to ask, do you have some figures on how many companies that are not registered with Part 16? Thank you. Right now, in Companies Ordinance Part 16, registered companies, they do not have a place of incorporation of Hong Kong, but they have registered with us to carry out business in Hong Kong. If they do not have business in Hong Kong, we would not have figures relating to such companies. But let me say this, with the redomiciliation regime, if a company is not incorporated in Hong Kong and they see that there will be benefits for them to redomicile to Hong Kong, whether in operation or in saving costs, that there are push factors for them to come to Hong Kong, this regime would be attractive to them. So for these companies that are not incorporated in Hong Kong, as long as they meet requirements, we welcome them here. For companies redomiciled to Hong Kong, once the certificate of redomiciliation is issued, they would have to comply with the requirements of Hong Kong. If there is any change, they would need to file such change with the company's registry, and the company's registry will update its website accordingly. They would also need to compile annual returns and conform to any listing requirements. That is, they will have to follow the requirements of Hong Kong essentially. Chair, I think they gave the right answers. I'm asked a question because the companies that do not carry out business in Hong Kong, they are relevant in some way. How can we do more with these lurking companies? They play an important role in Hong Kong still. How can we make sure they will float out of the water and officially register with us? That will enhance transparency and they will be subject to regulations such as national security as well as financial regulation. We're not trying to pressure them in compliance. It would, of course, be freer if they do not have to register with us. But we want to try to perform some sort of regulation still. So for these companies incorporated elsewhere, should we try to make sure they are floated out of the water at some point in time? I think, as Dr. Junius Ho said, this kind of companies would amount to many in Hong Kong, probably even more than 15,000 companies. We have 3 members speaking for the second round, Ms. Carmen Khan, Mr. Adrian Ho, and Ms. Doreen Kong. Ms. Carmen Khan, I want to ask, how much time do we have? 5 minutes. Thank you, Chair. We recently have another minimum top-up tax bill that is being scrutinized, and that is also led by the Financial Services and the Treasury Bureau. I hope the 2 teams would liaise with each other. It is because we have to implement the BEPS 2.0 framework that we have more companies incorporated in traditional tax havens such as Bermuda and Cayman Islands that are being pushed due to the global minimum tax initiative to redomicile elsewhere. They are faced with higher compliance costs now. We need to make sure we are competitive against other tax jurisdictions when we are trying to attract these companies to redomicile to Hong Kong. I believe what the chairman said would be attractive about the stamp duty concessions, and it is what I heard from stakeholders as well. For companies not incorporated in Hong Kong, while I do understand that they would enjoy the same status as Hong Kong incorporated companies, that they would have the same treatment, but for those redomiciling to Hong Kong, if they do not have to pay stamp duty in their original jurisdictions, wouldn't that kind of drive their shareholders to think Hong Kong is not that attractive as a destination for redomiciliation? I also want to ask, for some jurisdictions such as Bermuda, has the administration told companies in Bermuda we now have a redomiciliation regime, and this is allowed in mainland law? In fact, for many insurance groups, they are incorporated in the mainland. We have calls from the insurance sector for a redomiciliation regime, and we should not exclude those in the mainland. We should probably look at how deregistration works in the mainland. They probably do not have specific requirements at the moment for companies redomiciling to elsewhere cited as a reason for deregistration. Is it allowed in mainland law? As I know it should, but I would like to see confirmation on this. And as Dr. Junius Ho said, have you considered not only publicizing the regime to companies outside mainland Hong Kong, but also companies in mainland? We have many advantages. We have a sound legal system. We are internationalized. We have a good tax system. We should promote these as well. Deputy Secretary. I will first talk about the part about BEPS 2.0 framework. As Ms. Carmen Khan said, we are also scrutinizing the minimum top-up tax bill at the moment. And for the BEPS 2.0 framework, the implementation of which is definitely a push factor. If Hong Kong implements the BEPS 2.0 framework, there will be certainty that for a Hong Kong tax resident, they would fulfill the BEPS 2.0 requirement after they have paid taxes in Hong Kong. They would not be required to pay minimum top taxes in other jurisdictions. In this bill, in tax-related legislation, we will also talk about how redomiciled companies would be regarded as Hong Kong incorporated companies. That should provide some certainty in the sense that if the company becomes a Hong Kong resident entity, they will also enjoy the benefits brought about by Hong Kong implementing the BEPS 2.0 framework. As for whether the redomiciliation regime will be applicable to mainland companies, as I understand right now, the mainland does not have an outward redomiciliation regime, but we do afford some flexibility that we would allow redomiciliation of companies from jurisdictions that do not prohibit redomiciliation, and as long as they can register in the place of incorporation. And we would offer benefits in the sense that we would allow the companies to maintain their legal entities and their business continuity in Hong Kong. This should help interface with jurisdictions that will have outward domiciliation regimes in future. I think we should promote the companies in the mainland. Recently, we have had some deregistration guidelines issued by the mainland last year. So I think the registration is allowed. If you can liaise with the mainland authorities on this, I think they may put in place an outward redomiciliation regime in future. Thank you, Mr. Adrian Ho.
Chairman, Mr. Ambrose Lam just now described this as an investment scheme for people who would like to migrate to Hong Kong. Well, we have to offer some incentives for companies to redomicile to Hong Kong. We can, through the passage of the bill on minimum tax for multinational enterprise groups, we will be able to enhance our competitiveness and will be comparable to BVI and Cayman Islands. BVI and Cayman Islands are known to the world as tax havens. My question is, with the introduction of the redomiciliation regime, in the hopes that global companies would redomicile to Hong Kong, well, there might be the situation where intermediaries or agencies would take advantage of this regime. And companies might exploit the loopholes and evade tax in Hong Kong through their corporate structures. Will the Inland Revenue Department put in place measures so that we will not be known to the world as a tax haven like Cayman Islands, while we do not compromise our competitiveness? The administration does not intend to impose any economic substance requirements on incoming companies, and companies might establish shell companies in Hong Kong. They might exploit the loopholes through their corporate structures. There must be companies that want to evade tax through the regime. So how can we avoid this? How can we prevent ourselves from falling into such a trap? Administration. we have a robust tax regime. This redomiciliation regime will also be a robust one. We ask incoming companies to submit documents to us. For a company that wants to establish a new company in Hong Kong, it will only have to provide simple documents, but for redomiciling companies, we'll have to look at the background of the company's members. It will also have to obtain the legal opinion from a legal practitioner practicing the law of the original domicile of the applicant. It will also have to inform all the creditors, and it will have to obtain the consent of the members of the company in order to complete the redomiciliation process. All these will help ensure the background of the applicant company. If necessary, the company registry may ask for more information from the applicant as well as from the original domicile. So we are confident that we'll be able to put in place a robust gatekeeping system. On the point about tax evasion, a redomiciling company will transfer its domicile from one jurisdiction to Hong Kong. It might not have any direct implication to the amount of taxes it's going to pay. A simple change of place of registration of a company will not affect the amount of taxes that a company has to pay. As the Deputy Secretary said, when the company registry vets an application, it will have to look at the background information of the applicant company. So there won't be cases where shell companies could be set up in Hong Kong to evade tax. We have the CDTA arrangement with other tax jurisdictions, and there's an article about intelligence exchange with these tax jurisdictions. Other jurisdictions can ask Hong Kong to provide information about the tax of other companies to combat tax evasion. Can you tell us how many places have signed the AEOI with Hong Kong? Well, for CDTA, we have signed such an agreement with 51 tax jurisdictions. We also have something called tiers. It is not a CDTA, a comprehensive avoidance of double taxation agreement. It is just an information exchange arrangement. Ms. Doreen Kong. Thank you, Chairman. For redomiciled companies, there might be registration charges. How will you protect creditors concerning the arrangement for charges of registration? My second question is about the registration. Like those in Jersey, well, there isn't a deregistration system in places like this. For companies with original domiciles in places where there are no deregistration systems in place, how will you deal with such situations? Also, you're going to check the solvency of the incoming companies. Will you look at their contingent liabilities for existing litigations? Will that be part of the declaration for the applicant companies? Understand that in the forms, the applicant will have to make several declarations. For example, they'll have to declare that they did not or will not defraud their creditors, they'll also have to make declarations on their solvency. In case they make false statements or declarations, what will be the penalty? Lastly, in relation to the application time frame, it is not spelled out clearly in the bill how long the application process will take. 4 questions. I'll ask the company registry, Justin, to talk about the point about solvency and declarations. On charges of registration and solvency, I'll ask Justin to supplement. On the registration system, this is a very basic requirement on our end. We ask redomiciling companies, as I said, first of all, we have to make sure that the original domiciles do not prohibit the company to redomicile to other places. Secondly, we have to make sure that the redomiciling companies will deregister from their original domiciles. This is a very basic requirement on our part. Also, the applicant will have to obtain a legal opinion from a legal practitioner practicing the law of the original domicile, showing that the company will have the resources to comply with the relevant requirement. Say there isn't a deregistration system in the original domicile, the applicant will not be able to complete the redomiciliation process. Also, we try to compress the application time as much as possible. We ask that the applicant complete the deregistration from the original domicile first before completing the redomiciliation process. On the application time, we won't spell out clearly how long the application procedure will take in the bill, but we have talked to the company's registry. At the initial stage, we will not come up with a performance pledge, but we believe after collecting all the documents required, it will take about 2 weeks for the applicant to complete the application process, given that all the required documents are submitted. The other question concerned the penalty. When a company applies to transfer its redomicile, it has to go through 2 stages. We might penalize the applicant if the applicant submits false statements or false declarations. Section 895 of the Companies Ordinance stipulates that a false statement could amount to a criminal act, and the maximum penalty would be 2 years of imprisonment and $300,000 of fine. After we issue the certificate of redomiciliation to the applicant will be regarded as a Hong Kong incorporated company, and it will have to comply with the laws in Hong Kong. The company's registry will tell you more about the charges of registration as well as the solvency requirement. On registration charges, say a company is a foreign company and that it is registered as a company in Hong Kong under Part 16 of the Companies Ordinance. There are certain charges of the company that will have to be registered. In case such company is transferring its domicile to Hong Kong, we will specify that the charges will not have to be registered again. That is, for companies that are registered under Part 16 of the Companies Ordinance, we will check whether there are any subsisting charges. For companies that aren't registered under Part 16, or there are companies that do not have to be registered under Part 16, there is a clause in our bill that requires the applicant to register the charges within 1 month after it has become a redomiciled company. Because a redomiciled company will be regarded as a Hong Kong incorporated company, so we will see whether the charges have been settled.
我想接續
Mr. Rincon, I want to ask about for jurisdictions like Jersey. It's not that they do not have or they prohibit outward redomiciliation. It's just that they do not have a specific process for deregistration. They will not therefore be able to provide any proof that the registration has been made. I also have a follow-up question on charges. If they have registered some charges in their original domicile, they were not required to register charges in Hong Kong before. For these types of companies, do they need to register their charges all over again in Hong Kong? This is very important for the protection of creditors. So what will happen for these types of companies? Companies registry, Ms. Majestic Young. Thank you. On the point made by Ms. Young, if the companies have never registered the charges in Hong Kong, they have never registered under Part 16, or they are not required by company law in Hong Kong to register such charges. Once they are redomiciled to Hong Kong, if there are charges that have to be registered for other Hong Kong incorporated companies, the redomiciled companies would have to register the charges within a month. Thank you. Thank you, Chair. I have no other questions. Ms. Carmen Khan, speaking for the third round. I want to ask about paragraph 21 of the LegCo brief about insurance companies and banking institutions. It says here in the insurance and banking regulatory regimes, there are some differences in the regulatory requirements in respect of Hong Kong incorporated and non-Hong Kong incorporated entities. Say for insurance companies, do they need to deregister in their place of incorporation first before they can meet the relevant requirements of the regulators? Also, can you talk about what the differences in the regulatory requirements for Hong Kong incorporated and non-Hong Kong incorporated entities? Why there is a need to implement specific requirements for insurance companies and banks or financial institutions in general? For the fees and the 120-day requirement, I urge the administration to review these. The 120-day period, I understand, is a balance struck with reference to feedback from stakeholders, but as Mr. Rincon and I said earlier, there is uncertainty. So the companies would have to register charges, for example. So after the issuance of the certificate of redomiciliation, you would have these companies having 120 days to deregister. And during that time, there may be some third-party transactions, but you require them to register charges within 1 month. And we have seen in the UK's consultation paper that they are setting the period to be 60 days, so that is probably a point of reference. I also urge you to increase your fees. We should not only operate on a cost recovery basis. Thank you. Deputy Secretary. I would first like to respond to the question on regulation for insurance companies and financial institutions. Indeed, there are some differences in the regulatory requirements in respect of Hong Kong incorporated and non-Hong Kong incorporated entities. For the insurance sector in particular, for the appointment of certain personnel, for Hong Kong incorporated companies, they would be regulated. But then with the risk-based capital regime implemented, we have for some Hong Kong incorporated insurance companies facing more stringent requirements. This is to ensure stringent regulation of companies in the relevant sectors. And with these companies, they would need to first apply to the regulators for their assessment as to whether it is deemed that they can fulfill the applicable requirements upon redomiciliation. It is only after assessments have been made by regulators that the company's registry would issue the certificates of redomiciliation. But during that period of time, the company's registry will maintain close communication with the authorities, and the relevant companies will also have to conform to the requirements of Hong Kong until even without them completing the deregistration process. This is a requirement specific to the insurance and banking sectors to make sure we will have companies conform to the relevant regulatory requirements. As for the 120-day requirement, we have talked about our justifications. There are some risks, but then we also understand that there is a need for companies to complete the relevant process. And we believe within 120 days they would be able to complete the process. But let me say this, on day one we would have already issued the certificate of redomiciliation, and as I said earlier, they would already be regarded as Hong Kong incorporated companies, and they would face the same level of regulation as Hong Kong incorporated companies. Thank you, Mr. Ring Kong. I only have 2 comments to make. In the first round, I talk about some considerations. We often talk about, say, for insurance companies or financial institutions, and we have pretty much limited our discussion to listed companies. But then in future, we may have other types of companies come to Hong Kong. Would one of the considerations be national security when the registrar thinking whether to approve or refuse the application? And the administration said the requirements would be that it cannot be unlawful purposes or contrary to the public interest. I understand that UK's proposed regime is this. Not only can it be contrary to public interest, it cannot endanger national security, because for public interest and national security, they are 2 different considerations, and they would have different defenses. I urge the administration to review this, since the UK is considering national security. I'm not saying we need to follow suit exactly, but I guess it is right that we need to review this to see whether to include national security threat as a factor for consideration. With fees, we have been talking about higher charges for transportation or other hospital treatments, for example. We're talking about listed companies here. I'm not asking you to charge exorbitant fees, but you are taking 2 weeks to process their applications, you need to review the documents submitted. You have teams to deal with this. I honestly doubt whether the level of fees you're charging can recover the costs, so I hope you can review the fees as well. Thank you. I believe the administration notes Ms. Doreen Kong's suggestions and would review this as necessary. Ms. Carmen Khan, I have only one point to make. I would like to echo on the point made by Ms. Doreen Kong. I think the administration can give a written reply. We can first have the administration talk about whether public interest would already include the consideration about national security, or do we have to explicitly say national security? I think with the registrar refusing the application afterwards, it would already be the case that for some period of time the company would be regarded as a redomiciled company. There may be some issues. Mr. Porter, I understand the two colleagues expressed concerns about the national security factor, but I think public interest should include national security already. I think no national security threat would be able to pass the public interest test. So it is exactly why national security law has a public interest defense, because with public interest it is a bigger factor. And I think with redomiciliation, let's not focus our discussions on national security. We have been talking about this a lot, and this has already caused some worries with the foreign companies and bodies. I think public interest alone should be adequate. I think different members have different opinions. I think the administration can perhaps talk about whether they have considered this when they're drafting the bill. Thank you. On the national security factor, we thank members' comments. As said earlier, we may provide a written reply after the meeting. Right now, there are two factors to consider when the registrar is vetting the application. If it is believed that the applicant is likely to be used for unlawful purposes or purposes contrary to public interest, then for the first factor alone, unlawful purposes, if it is against the law, that would include national security law. That would already be right for the registrar to refuse the application. And on top of that, we also have the public interest consideration, so that should be more than enough. DOJ, anything else to add? As the Deputy Secretary said, apart from the gatekeeping done in the application stage, in Section 360C of Chapter 32, there would already be companies that would be subject to regulation, in the sense that if the Secretary for Security thinks that a company is breaching national security law, they may revoke the status of companies. Thank you. All right, any other members who would like to ask policy-related questions? Ms. Carmen Khan. Since you have already looked at how the public interest consideration would already cover national security, why is it that the UK specifically said that national security should be considered as well? I think this is just a comment. The administration can review this, and you may provide a reply at the next meeting. Any other members who would like to ask policy-related questions? If not, I would like to consult members on an issue. Should we invite public submissions on the bill? We may invite public written submissions from the public, or we may hold a public hearing. And between March and May of 2023, the administration has consulted relevant stakeholders, and in July 2023, the administration consulted the Legislative Panel on Financial Affairs. This is for members' reference. So what are members' opinions on this? I think members would like to invite written submissions from the public. The Secretariat will post a notice in due course on the Legislative website inviting written submissions from the public. The submissions received will be forwarded to members as well as the administration for the administration to give a consolidated response. We have 15 minutes left. Let's go into clause-by-clause examination. Please refer to CB brackets 21737/2024, the bill, as well as the marked up copy, CB brackets 1185/2025 brackets 01. To facilitate the public and members' reference, I ask representatives of the administration to refer to the page numbers of the marked up copy. I now ask the government to start clause-by-clause examination.
Thank you, Chairman. Let me proceed with the clause-by-clause scrutiny. Part 1 of the bill is a short title. This ordinance may be cited as the Companies Amendment Number 2 Ordinance 2024. Part 2 is the amendment to the Companies Ordinance. Part 3 is the amendment to the subsidiary legislations. And Part 4 is the amendment to other enactments. Administration, could you please read out the long title of the bill? Yes. Amend the Companies Ordinance, including its subsidiary legislation, to provide for a regime to enable a company incorporated outside Hong Kong to transfer its domicile to Hong Kong, to provide for related matters, and to make related or technical amendments to the ordinance and other enactments enacted by the Legislative Council. Please carry on. Part 2. Page 1 of the marked up copy. We will first amend the interpretation of the Companies Ordinance. That is to add a definition. We will repeal the part about domiciled company. We'll also add in the definition for non-Hong Kong companies and so on. Pages 1 to 7 of the marked up version are the definitions for all these terms, including redomiciled company, redomiciliation date, and so on. We are adding section 2 bracket 5, a deeming provision, to this section. The purpose of this amendment bill is to make redomiciled companies the same as Hong Kong incorporated companies. And this deeming provision is to reflect this purpose. In the new Schedule 12, as well as the 5C, this deeming provision will not be applicable. Starting from page 9 of the marked up copy. On 5C, I think the legal advisor has a question. In relation to 5C, paragraph 1, according to the bill, this deeming provision will not apply to airline companies that are redomiciled companies. Can you explain why this provision will not apply to airline companies? Thank you. When we drafted this deeming provision, we consulted different policy bureaus. We asked whether there are situations in which Hong Kong incorporated companies or non-incorporated companies are considered differently. According to the policy bureaus, according to airline companies related ordinance, for airline companies that use leased aircraft, this will only apply to Hong Kong incorporated airline companies. 5C reflects this policy intent, and Schedule 12 sets out the exemptions to this deeming provision. Please carry on. Let me brief you on this part of the bill, starting from page 9. We will add in a new Part 17A on the effects of the redomiciliation regime. After adding in Part 17A, we have to make consequential amendments to other sections of the ordinance. And there are a few types of such amendments. That is, for existing provisions that apply to existing Hong Kong incorporated companies, they will apply to redomiciled companies. For legislations that apply to non-Hong Kong incorporated companies, they will not apply to redomiciled companies. There are also companies that are registered under Part 16 of the Companies Ordinance. For these companies, if they apply to become redomiciled companies, there will be transitional provisions to deal with such cases. So this is what Part 17A is about. Let me go through the clauses now. Page 9 of the marked up copy, we are amending the definition of relevant correspondence address. It will set out that a redomiciliation form of the company delivered to the registrar under Section 820B(2). We are also amending the Chinese references to register and registry. Would like to take this opportunity to make the Chinese references consistent. The term register will be used in forms which will be different from incorporation in Chinese. Are we doing clause-by-clause scrutiny, or are we listening to the briefing from the administration? For page 8 of the marked-up copy, I have questioned about 5C, but the administration went through that part very quickly. I want to know if we are going through the bill clause-by-clause. We are now at the clause-by-clause scrutiny stage. Perhaps Ms. Kong can ask about 5C now. Thank you, Chairman. Page 8 of the English marked-up copy. Now, I understand 5A. It says a redomiciled company is to be regarded as a company incorporated in Hong Kong with effect from its redomiciliation date. Now under 5C it says subsection 5A does not apply to a redomiciled company that is an airline. But I don't understand 5C bracket B. Mr. Lee? As mentioned, this is a deeming provision, and 5C sets out the exemptions. We set out the exemptions where subsection 5A does not apply. The differences between 5B and 5C is that 5B does not set out the exemptions. Five B corresponds to the amendments to be made in Part 4, that is to the 39 other enactments. I'm not referring to 5B. I'm saying 5C bracket C. Please explain this phrase. For 5C bracket B, do you understand that we have to look at 5A? It says that a redomiciled company is to be regarded as a company incorporated in Hong Kong. 5C bracket B clarifies that the redomiciled company is to be treated as a company incorporated in Hong Kong. But it won't be regarded as a company incorporated or formed and registered under this ordinance. That means it doesn't mean that the company is formed under the company's ordinance, while it will be regarded as a company incorporated in Hong Kong. What is the reason for this provision to be here? There might be a rationale behind for you to include this provision, but what is the reason behind? Is it because under the company's ordinance there are many provisions? Is it because there are still some differences between redomiciled companies as well as Hong Kong incorporated companies? That's why you're including this provision? Perhaps I'll ask the DOJ to explain. The member is correct. If you looked at page 1 of the marked up copy, there is a definition that applies to the entire company's ordinance. That is the definition of company. It says company means a company formed and registered under Cap 622 and an existing company. Existing company are companies established under Cap 32. That is the former version of the company's ordinance. We are adding in subsection C here. A redomiciled company will be regarded as a company as well. So we are introducing 5C bracket B here on page 8. If we do not spell out clearly that these companies will not necessarily be regarded as incorporated or formed in Hong Kong, they will fall into the definition of A or C. Say there are companies that are registered in Hong Kong, but for different reasons it has redomiciled to other places, and now it has chosen to transfer its domicile back to Hong Kong. Now, before the administration addresses this question, I'd like to extend this meeting for 15 minutes so that this question can be addressed. Any reply from DOJ? As far as we understand, there's currently no regime in place for companies to redomicile to other places. That's why we have this amendment bill. For a company which is registered in Hong Kong, there isn't an outward regime for for that company to transfer its domicile to other places. However, if that company is registered under Part 16 of the Companies Ordinance, and through this regime, it has applied to become a redomiciled company. And on the day it becomes a redomiciled company, the registration under Part 16 will be terminated.
係主席，
Ms. Carmen Khan. Thank you. I want to ask about the definition of redomiciliation date. It is quite important because with this, we will know what will apply to companies formed and registered under Companies Ordinance and redomiciled companies. It says here it does not apply to a redomiciled company that is an airline, for example. So I want to ask, what does redomiciliation date mean? Is there any window of time when there is an overlap? Well, there will be an overlap, but does the definition of redomiciliation date account for this? So what will the redomiciliation date mean? Thank you. According to 802A, with the definition of redomiciliation date, that would be the date on which the certificate of redomiciliation is issued. In that case, the redomiciled company would be regarded as essentially incorporated in Hong Kong while being registered in another jurisdiction still. I urge the administration to make sure this period as short as possible. I want to ask, where is Section 828? Which page is it? It is in 125, page 125 in the Chinese text. I believe members still have some doubts about the 120-day requirement, because with 120 days, the company being domiciled in two places would be a problem. And I think in the industry, it is not good to have two domiciles, because it would mean the company would have to comply with requirements in two jurisdictions. For third parties, there can be risks as well, because when conducting transactions, they would need to make sure only a jurisdiction's laws would apply. When two jurisdictions' laws apply, there can be some confusion which jurisdiction's laws are to be followed. I want to ask the DOJ stance on this. Does the DOJ want to give a written reply at the next meeting and perhaps give a reply on the 120-day requirement with the companies having two domiciles for the contracts entered, whether these will follow Hong Kong laws? Is it possible? Is it appropriate? I urge the administration or the Bureau to liaise with the DOJ on this, because this has some implications on litigation in future. Because with the companies having two domiciles, it can be an issue. For example, which courts to go to. I think that would be an issue. I understand the legislative intent is to provide flexibility to companies, to provide adequate time for companies to deregister, but then there may be legal implications, and I think the administration can provide a reply on how we can make sure there is no confusion in this area. And you may provide a reply at the next meeting. I have extended the meeting to 15 minutes. I would like to say, while we're at this, we will end the discussion of the clause-by-clause examination for now. I would like to ask if members would like to propose any other business. If not, we have already discussed with the administration. We have reserved a time slot at 9 in the morning on 17th of February. Will members please note the date and time? If there's no other business, meeting adjourned. Thank you.